Hey y'all, welcome back to this week's episode of AMA Friday with Amy Miller, recruiting in yoga pants. So this week we're going to tackle the hot new topic over on LinkedIn. I'm seeing a lot of these posts lately, y'all. Some I'm sure are, very well intentioned and trying to be, uplifting, and others, man, are you just chasing the dopamine now at no matter who it hurts? I don't get it. I have scrolled past so many posts lately. Just saying. My 5-minute rules helping. Anyway, let's get to it, shall we? So I want to dig in a little bit to this idea around work authorization, sponsorship, employer sponsorship of workers. So a couple of caveats before we start. First of all, I am a US-based recruiter. Okay, so this is specific to the United States, working in the US for US employers. Your personal mileage in other countries is going to vary widely, and I highly, highly, highly recommend that you talk to immigration experts. Get an immigration lawyer. Go to the country's specific website. In the United States is uscis.gov. That is our what does that stand for? United States Citizenship and Immigration something. Anyway, lots of good information there, lots of data about the different kinds of visas, the forms, the fees, the everything. So do your due diligence, do your homework. Do not take legal advice from people who are not actually lawyers as a start, okay? And especially me. The other thing is, this is also through the lens of my personal experience recruiting and making offers to visa dependent folks, or folks who needed work authorization. So I am happy to walk you through that part of it. Hopefully it sheds a little light on this topic, gives you some starting points to think about, questions to ask, that kind of stuff. So all right, let's jump in, shall we? So the first thing to wrap your heads around, this is so important. It is not up to the company. It is not up to the individual hiring manager. It is not up to the recruiter. Even the company, even the CEO of a company still has to go through a certain process in order to hire people and then sponsor them if they do not otherwise have work authorization. Your argument, a lot of times, is with the government. They're the ones that have the rules. They're the ones that we have to pay taxes to. They're the ones that, created these processes and forms and fees. And you cannot be mad at a company or an individual for not providing sponsorship if the system has not been set up in a way that we have the capability and the funds and just the freedom and flexibility to do it. And here's why, okay? Work authorization dependent hiring can be very lengthy and very expensive. Typically, particularly with larger companies, they kind of have a blanket rule, so to speak, or a general guidance that we do provide sponsorship. So we will consider, new hires who already have work authorization. Maybe their H-1B, for example, is very, very common in tech, very common visa category. Maybe that H-1B is held by another company. We can hire on a transfer basis. We're happy to do that. We can hold an H-1B. We can hold a visa for an employee. So companies decide that they can or cannot do that before hiring plans even come about. Before we even start thinking about headcount or hiring needs or whatever, a decision is typically made or a policy created for a particular company that yes, we can sponsor in these circumstances for that kind of, engineer or whatever industry title. And we can do that in certain locations, maybe headquarters, maybe satellite sites, what have you. Okay. So the whether or not a company can sponsor, hopefully, is ironed out long before they ever start recruiting. Okay, so let's say, great, I've got a company that can provide sponsorship. Fantastic. How do we do that? So now, we're going through the hiring process. We are treating, and this is my personal experience speaking from here, we are treating every applicant exactly the same. We're not looking at it and going, oh, that person needs a visa. Oh, no, we're not going to consider them. Never happened to me anyway. I've never done it. I've never known anyone to do it unless there were specific requirements that stated otherwise. Cleared roles, companies or projects within companies that have ITAR restrictions or export control restrictions. There may be other legal things that would stop that, but we have absolutely 100%, and I'm pretty sure this would be illegal, if not at the very least unethical, have never made an interviewing decision based on someone's work authorization. Again, outside of those very specific legal reasons. Okay, so let's say our best candidate, the person that we want to hire, is on an H-1B. No problem. We have a transfer process. So this is typically what would happen. All right, so we would, when we do the initial phone screen, we would ask the question, do you now or will you in the future need authorization to work in the United States? Sometimes it's a knockout question. You can say yes or no to that, depending on, again, the way it's set up with the company. A no question might get you knocked out. I don't know. For me, when I use that as a knockout question, a yes meant I need to do a visa evaluation. A visa evaluation is when you and I have gotten on a call, I'm doing my recruiter phone screen thing, I'm checking all the boxes I need to check, and I'm saying, great, we want to move to the next step. You're going to interview with this person, that team, whatever. While we're conducting these interviews, I'm also going to ask you to provide information to our legal counsel so that we can run a visa evaluation so that we understand what are the steps we'll need to take to finalize your employment should you get an offer from us that you decide to accept. Okay? Visa evaluation, in my experience, a couple companies ago, there was a secure form you would fill out, you would upload information that they asked for, the lawyers would review it, there was an entire team that dealt with all this, and they would tell me, yep, you're good to proceed. Yep, here's the thing, they've got an H-1B, they're eligible for transfer, they've got 5 years left on their visa, no problem. We put them in the next H-1B lot or the next green card, whatever, get them a green card when they join, whatever. That's a whole other process we'll talk about another time. So that was it. That was it. This was, again, just a way to kind of confirm that we were good to proceed, that we didn't have any restrictions or legal blockers. We would go through the process, we would interview you, would make you an offer, lawyers would take over and do their thing as far as work authorization. Okay, that's fine. Then we have folks who do not currently possess work authorization or who are not currently sponsored for employment. This can be student visas, like OPT is a common one. I think there was a J1 I ran into a lot when I was doing research stuff, hiring a lot of PhDs, things like that. These also come with very specific restrictions. It can be restrictions around the number of months you're allowed to work. Definitely restrictions around like the field of study, STEM degrees typically, and even within STEM, sometimes very narrow, master's degree or PhD sometimes in certain cases. There was also just restrictions on timing, right? When you could start. We would have to go through all these steps, get everything approved, pay the money, get the letter from USCIS, what have you, and then you could set a start date. So it wasn't unusual for start dates to be 6 months out. Now that's fine when you're a massive company and you've got 100 engineers working on this project and you can afford to wait 6 months for your newest engineer who's just getting out of college or just going through this immigration process. I don't want to discourage anyone, but I also want to have a really realistic view of what's happening on the back end. Recruiters do not control this. All we can do is work with the information that we're given and within the constraints of our employer or client company. If they say they can sponsor and they're willing to do that, fantastic. If they say that they can't, it's just not financially in their wheelhouse, if it's not, they don't have the right, team size and infrastructure to support an extended wait time or what have you, I can't argue with that. I can't tell them they're wrong. Okay, so All the dear hiring manager, dear recruiters, I just save it because we're tired. All right. Again, your arguments with the government, go tell them to clean up the immigration process, make it smoother and easier. And, like when my great great grandparents came over, I mean, they didn't deal with none of this shit. I'll tell you what. So, they just packed up their potatoes and hopped on a boat. Right. So anywho, great. Yeah, I think it's great. Anyway, so, I just want y'all to go into this eyes wide open. That's all. Right? I'm not trying to discourage anyone from applying to companies or taking chances on those roles. I think y'all are so brave. I mean, to leave your country, to go somewhere where you don't know anyone, you've never lived. It's a lot. It's a lot. And I admire that quality. I really do. But I also want to be realistic about what the hiring process looks like and why these dopamine chasers on LinkedIn are just doing you a disservice. Okay? So please do your due diligence, do your research, look at the country that you're looking to work in, look at their specific immigration laws and policies. Find a good immigration lawyer. Maybe you can get a free consultation. Maybe they have a blog or website or something that provides free insights that you can start with. Find people who've been in your situation. Right? Find people who have gone through that hiring process, who were brought on one of these visas, who won their spot in an H-1B lottery. We didn't even get to talk about the lottery, which is a whole other process for folks who don't have that first H-1B, and they have to literally get picked out of a bunch of people. A lot of people don't get picked. And that can then create downstream impact, trying to get extensions on J1s and things like that. Like it's a lot. Which is why it is best left to the lawyers. Okay? So again, do your homework, look at the country that you're trying to work in and understand as best you can their immigration laws and their work authorization rules. Find immigration support in the form of lawyers, ideally, who do this for a living and can navigate the very, very complex language and forms and fees that come with it. Talk to people who've successfully done it. Just like with networking, look at folks who have experience in this, who can share their own personal stories. It doesn't mean your situation will unfold exactly the same, but I would definitely take guidance and input from those people before I would a self-appointed thought leader who wanted to get some clicks and likes. Just saying. All right, y'all, I hope that helps. I definitely went over this week, but it's a really important topic and I wanted to be as clear as I could. So again, keep in mind, it starts with the organization and what they absolutely can or cannot support. It is not subject to hiring manager whims and certainly not subject to recruiter decisions. We do the best we can with the information we have, the guardrails that are put up, and hopefully always thinking about what's best for our candidates and our employers. All right, y'all, have a great weekend and we'll see you next week.